Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss the case of Shri Hari Hanuman Das Totla versus Hemant Vitthal Kamat and others, wherein the Honorable Supreme Court discussed Order 7, Rule 11D of the Code of Civil Procedure. This provision deals with the contingencies under which a plaint could be rejected by the trial court where the suit appears from the statement in the plaint to be barred by any law. To read further about it, kindly refer to my earlier post in the year 2018 at the link pasted in the description. The defendant or the appellant in the present case preferred an application under Order 7, Rule 11D of CPC before the trial court, inter alia on the ground that the suit is barred by a law, that is, res judicata under Section 11 of CPC. Such application was rejected by the trial court, against which the defendant or the appellant preferred civil revision under Section 115 of CPC before the High Court. However, the same was also rejected by the High Court. Hence, the defendant or the appellant approached the Honorable Supreme Court. Before adverting any further, let us peruse the relevant provisions of the Code of Civil Procedure. Order 7, Rule 11D of CPC. The plaint shall be rejected in the following cases. D. Where the suit appears from the statement in the plaint to be barred by any law. Section 11 of CPC was also discussed that talks about res judicata. It provides that a court shall not try any suit or issue in which the matter that is directly in issue has been directly or indirectly heard and decided in a former suit. Now let us discuss the pertinent observations by the court. Firstly, the court noted that whether a suit is barred by any law must be determined from the statements in the plaint, and it is not open to decide the issue on the basis of any other material, including the written statement in the case. Secondly, with respect to res judicata, the court opined that to adjudicate res judicata, it is imperative to refer to the copies of the pleadings, issues, and the judgment of the former suit. According to the court, the plea of res judicata is founded on the identity of the cause of action in the two suits, and such pleas cannot be left to be determined through speculation, as res judicata involves mixed question of law and fact that cannot be examined without looking at the evidence in the earlier suit. Thirdly, the court observed that to invoke Order 7, Rule 11D, it is required to be shown that a suit is barred under any law, and such conclusion has to be necessarily drawn only from the averments made in the plaint, and no amount of evidence could be looked into. The merits of the matter are not within the realm of the court at the stage of deciding an application under Order 7, Rule 11D of CPC. Further, even the written statement of the defendant cannot be looked into at that stage. Fourthly, the court also observed that if different provisions under Order 7, Rule 11 of CPC are invoked in a same case, then a clear finding to such effect must be arrived at. Fifthly, the court also opined that though it is inappropriate to invoke the plea of res judicata at the stage of deciding an application under Order 7, Rule 11 of CPC, yet it is within the powers of the trial court to take up such issues that relate to maintainability of a suit and decide them at first instance. This would save precious judicial time. Sixthly, the court postulated four cardinal principles to decide an application under Order 7, Rule 11D of CPC. A. To reject a plaint on the ground that a suit is barred under any law, only the averments in the plaint are to be looked into. B. The defense or the written statement of the defendant cannot be looked into while deciding such an application. C. To determine res judicata, provisions of Section 11 of CPC have to be looked into and complied with. D. However, the plea of res judicata is beyond the scope of Order 7, Rule 11D of CPC. Therefore, upon cumulative consideration of the matter, the Supreme Court was of the view that since prima facie reading of the plaint does not disclose that it is barred by res judicata, pleadings, issues, and judgment of the former suit would have to be looked into, and hence the trial court rightly rejected the application of the defendant or the appellant under Order 7, Rule 11D of CPC. That was all about the case, so what are my concluding remarks? Order 7, Rule 11D of CPC is a handy tool for the litigants to make sure that a plaint that is otherwise barred under any law does not see the light of the day and is rejected at the threshold, saving precious judicial time. However, technical pleas such as that of res judicata that require a deep scrutiny of the pleadings, issues, and judgment of the former suit cannot be considered to be a bar in terms of Order 7, Rule 11D of CPC, unless the same could be established by mere averments of the plaint. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.